Good afternoon. Thank you all for being here. Kevin Johnson, Dean of the Law School. Today, we are lucky to have University of Pennsylvania law professor and history professor, Serena Myrie, to deliver the Bodenheimer Lecture on family law. Now, this lecture was established in 1981 in memory of UC Davis law professor Brigitte Bodenheimer, an internationally renowned teacher, scholar, and law reformer on family law. And the idea was to bring scholars to discuss legal developments affecting the family in this series. Now, today's event is also part of our Racial Justice Speaker Series, which is in its third year and explores the nation's systemic racism and its effects on all areas of law and communities of color. And reproductive rights is one of those areas of law. Professor Myrie's lecture today, Marital Supremacy and Reproductive Injustice, I almost said justice, which would have been a big error. We'll explore how in the last 4 decades of the 20th century, social movements and cultural transformations tested a U.S. American legal regime that channels key public and private benefits through marriage. She'll spotlight challenges to marriage's legal primacy that advance reproductive justice aims. Professor Myrie asserts that understanding these visions of sexual citizenship, racial and economic equity, and family status equality, and the obstacles champions faced helps explain how marital supremacy and reproductive injustice adapted and survived to this day. Now, Professor Myrie teaches and writes about legal history, equality, work, and the family. Her book, Reasoning from Race, Feminism, Law, and the Civil Rights Revolution, received many awards. She's currently working on a book exploring challenges to the legal primacy of marriage in the United States since 1960. Her scholarship has appeared in edited volumes and leading law reviews. He's been named a distinguished lecturer by the Organization of American Historians. She also received the Robert A. Gorman Award for Excellence in Teaching just a couple of years back. She has a JD as well as a PhD in history from Yale and clerked for Judge Guido Calabresi of the U.S. Court of Appeals for the Second Circuit. Please welcome Professor Serena Myrie.
Thank you so much, Dean Johnson, for that wonderful introduction. It's really an honor to be here presenting a lecture in memory of Professor Bodenheimer, and also really a pleasure to be here at UC Davis for the first time. It has a special place in my heart, both because I grew up in Northern California and also because of all of the wonderful friends and colleagues who've been part of this faculty in the past and in the present, and from whom I've learned a tremendous amount and continue to learn a tremendous amount. Thank you all for being here today. And a particular thanks to Dean Johnson and Dean Afsharipour and Starla Bennett and Onel Barrios for making my visit so enjoyable and for all of their help. So the title of my talk today includes the term marital supremacy, and I wanted to say a little bit about what that means, because it might not be a familiar term. It might not be as familiar a term as reproductive justice may be. I'm using the term to refer to the legal primacy of marriage, the legal privileging of marriage, really, in both public law and private law. And I'm using marital supremacy not to denote a static phenomenon that is fixed in time, but rather one that changes over time. And those changes are the topic of the book project that I'm working on currently and have been working on for quite some time. Reproductive justice may be a more familiar term. Sister Song defines reproductive justice as the human right to maintain personal bodily autonomy, have children, not have children, and parent the children we have in safe and sustainable communities. So I want to begin by going back in time to the mid-20th century United States, when a certain version of marital supremacy was at its peak. The New Deal welfare state presupposed a male breadwinner, female homemaker model in allocating public as well as private benefits. Women became eligible for social insurance primarily through their husband's earnings, and employment discrimination and discrimination elsewhere in society really limited their economic opportunities and their financial independence. Making heterosexual marriage the gateway to social and economic rights and benefits also magnified the effects of racial inequality. Black women in particular lacked access to the most generous benefits of the New Deal state, both because of the exclusion of domestic and agricultural workers from the Social Security Act of 1935, along with discrimination and segregation in really all areas of life. All of that made marriage to a breadwinning man both less attainable and less economically valuable to many women of color. Of course, Black women and other women of color, married or not, had long worked outside their homes in larger numbers than their white counterparts. By 1960, they were also significantly more likely to be supporting families alone or to be the primary breadwinners in their families. The Social Security Act was a two-tiered system, or established a two-tiered system. It offered entitlements based on waged work to presumptively white male breadwinners and welfare to single mothers. And until the 1950s, few women of color received public assistance under the Federal Aid to Dependent Children program, which was designed primarily to allow presumptively deserving white widows and abandoned wives to stay home and care for their children. As Black women slowly gained access to these funds, ADC became increasingly stingy and stigmatized. Whereas policymakers envisioned homemaking and caregiving as the ideal for white mothers, Black mothers had no such luxury. Right? They were expected to be supplying low-wage domestic and other labor for white employers. Anti-welfare sentiment grew as the public associated ADC with presumptively undeserving single mothers of color. At the same time, and not unrelatedly, resistance to racial justice movements' demands for the desegregation of schools and of public facilities fueled what we might think of as a moral panic about rising rates of so-called illegitimacy. Officials enforced old illegitimacy penalties and invented new ones. So just to give a few examples, suitable home laws denied welfare benefits to families with non-marital children or mothers who engaged in non-marital intimate relationships. Southern states used moral character provisions to exclude non-marital children from white classrooms and to exclude adult Black citizens from voter rolls. Other proposals, even more draconian and explicitly punitive, prescribed the sterilization or even incarceration of people who conceived and bore non-marital children. So with that backdrop in mind, what I want to talk about today is how single mothers, mostly Black single mothers during this period, used the law specifically to resist racial and reproductive injustice. And in particular, my talk focuses on examples from the mid to late 20th century, where their battles against reproductive injustice took the particular form of challenges to marital supremacy. So it turns out that a lot of what we might now characterize as reproductive justice efforts during this time were couched in terms of challenging the boundary between marriage and non-marriage and challenging penalties for non-marital childbearing and non-marital relationships. In April 1967, Barbara Jean Cager applied for AFDC benefits on behalf of her one-year-old and newborn daughters. At 19, she had already lost her own father, her first baby, Patricia, and Patricia's father. She lived with her own mother, 4 siblings, and 3 young children in housing without plumbing or heat, supported by her mother's work as a hospital maid. Barbara Jean had just given birth and planned to return to work herself in July. In the meantime, to receive public assistance, Maryland law required her to supply the name of her baby's father, although he was incarcerated and there was little hope of recovering child support from him. Unbeknownst to the Cager family, the local state's attorney, Arthur Marshall, had launched a campaign against illegitimacy and conscripted welfare officials to apprehend mothers who gave birth to more than one child outside of marriage. When Barbara Jean Cager signed the paternity declaration that was required to receive public assistance, she was advised of her rights, charged with criminal neglect of her children, booked and jailed. Prosecutors initiated proceedings to remove her children. These kinds of draconian actions were not new in the late 1960s, but what was relatively new was that they increasingly came under constitutional attack. So civil rights and civil liberties organizations came to Barbara Jean Cager's aid. The ACLU, the NAACP Legal Defense Fund, Planned Parenthood all saw Cager as a potential test case. Court documents and press accounts portrayed the young women in Cager, and there were several of them who were arrested in this way, as vulnerable victims of a cruel and inhumane policy, not as proactive authors of their own destiny. We know relatively little about their own aspirations and self-conception, thrust involuntarily as they were into the public spotlight. Not so for many Black single mothers who struggled in increasingly vocal and visible ways against morals regulations that aggravated desperate conditions for non-marital families living in poverty. Specifically, women of color used constitutional assaults on family status discrimination to articulate new visions of sexual and economic citizenship. Some challenged marital supremacy directly, questioned the privatization of dependency in the family, and openly rejected sexual conventions. Others thought less to reject respectability than to redefine it. So there were many sites for this struggle, and I'm going to talk about a few examples today. The first example I wanted to talk about is public housing. In the 1960s and early 1970s, in cities and towns across the country, single mothers began to challenge policies that excluded the parents of non-marital children from public housing. Like other punitive crackdowns on so-called illegitimacy, these policies sometimes often intertwined with resistance to racial desegregation, as was the case in Little Rock, Arkansas, where Alma Jean Thomas and Estella Watson filed a class action lawsuit in 1966, challenging their exclusion from public housing because they had non-marital children. Such policies, though, were equally prevalent in northern cities, and officials justified them on similar grounds, including the idea that sexual immorality would set a bad example for other tenants and their children and would undermine the legitimacy of the public housing program itself. In Philadelphia, for example, 13 women filed a lawsuit, including Mae Green, whose 3 unsuccessful applications for public housing forced her to place her 5 young children in foster care. Another woman, Zenobia Smith, was hospitalized for a breakdown caused primarily, she said, by her inability to secure decent housing and the fact that her 3 young children had to join her sister and 2 other children in a tiny 1-bedroom apartment. Welfare rights leaders in these cities, including Philadelphia, joined legal aid lawyers, local chapters of the NAACP, the Congress on Racial Equality, and the ACLU to lobby local officials to stage protests and to file lawsuits like the one in Philadelphia. Black single mothers who became welfare activists during this period articulated a distinctive vision of political economy and of citizenship. Historian Pramila Nadesan describes how leaders such as Johnny Tillman, pictured here, demanded the right to choose to be mothers or to enter the world of work outside the home, to date and have intimate relationships, to marry or to remain single. They opposed work requirements, but supported women's right to decent employment and fair working conditions. They demanded the right to control their own reproduction, choosing for themselves medicine rights, when and how to take birth control, to have an abortion, or to be sterilized. In other words, welfare rights leaders promoted what activists would later name reproductive justice, the right not only to avoid having children, but to have and raise them in safe homes and communities. Challenges to marital supremacy, it turns out, played a key role in this novel brand of feminist anti-poverty activism. One example of how this activism translated into litigation is a case called King versus Smith, Mrs. Sylvester Smith's challenge to Alabama's substitute father law, which I'll say a bit more about in a moment. This lawsuit not only underscored the racial motivations and effects of punitive anti-illegitimacy welfare measures, but also advanced a robust vision of sexual autonomy and privacy. When told that her family would be ineligible for ADC benefits if she did not disprove rumors of her intimate relations with a married man, Mrs. Smith told her white caseworker that the affair was none of her business, adding that she had every intention of going with whomever she wished, as long as she was young enough, as she put it, to enjoy the company of men. Mrs. Smith, who had been widowed at age 23, worked daily 8-hour shifts away from her family as a cook in Selma for less than $20 per week to support her 4 children and grandchild. She valued her social and sexual autonomy enough to risk losing the stingy but still significant ADC benefit for which her family was otherwise eligible. When she filed her lawsuit, she faced retaliation that sometimes left her unable to feed her family. The substitute father regulation, which is a regulation that essentially provided that if you had a man, if there was a man who you were in an intimate relationship with, that man should be responsible for supporting you financially, regardless of whether he was the father of your children. Imposed impossible choices on mothers, right? They had to either forego all contact with men, platonic or otherwise, expose themselves to gossip, ridicule, and the indignity of having their neighbors and caseworkers intruding into their personal relationships, or subject their children to starvation. Mrs. Smith's defiant declaration of sexual independence didn't translate perfectly into legal or constitutional claims, but her argument sounded in terms of sexual privacy and the right not to have government benefits conditioned upon marriage or celibacy. And I'll say a little more specifically about these constitutional claims in a moment. Other welfare rights plaintiffs emphasize single mothers' prerogative to make independent decisions about their family's welfare without interference from the state. Women who challenged a Connecticut law that forced unmarried mothers to disclose paternity or face fines and imprisonment these mothers were criticized by state officials and by some judges for depriving their children of paternal financial support and a relationship with their fathers. In response, these mothers insisted that keeping paternity private was the most responsible decision they could make for their families, when disclosure often meant disrupting existing relationships or risking violent reactions from former or current partners. The state, they said, should honor mothers' primary responsibility for non-marital children by assuming mothers' ability to make decisions in their children's best interests. Lois Fernandez, a Philadelphia community activist, was lying in a hospital bed celebrating the birth of her first child in 1967, when she learned that she could not obtain a birth certificate listing her as her baby's mother because she was not married. This, she soon discovered, was only one of many discriminations against non-marital children and their mothers in Pennsylvania law. As Fernandez later wrote to her state representative, "It is the feeling today that you can take a life, legally, abortion, but to give life is illegitimate." Fernandez spoke proudly of single motherhood as a morally valid choice worthy of equal dignity and regard, even celebration. After a decade-long battle, she and her allies succeeded in outlawing birth status discrimination in the state's inheritance and other laws, and won the right of single mothers to pass along their own surnames to their children if they chose. Notably, Fernandez fought what she described as, quote, the stereotype that mothers of out-of-wedlock children are promiscuous and were whores gobbling up welfare. Fernandez described herself as a homeowner and a working mother who belied such images. As this framing suggests, some sought to redefine respectability itself by rehabilitating the image of unmarried motherhood. Katie Mae Andrews's challenge to a rural Mississippi school district's exclusion of unmarried parents from teaching positions was one such effort. Like King versus Smith, Andrews's case was deeply intertwined with the struggle for racial justice. The disparate racial impact of excluding non-marital parents for these jobs was unmistakable, as was the discriminatory purpose behind these exclusions. The school district's attorney was segregationist Senator James Eastland's son-in-law. Andrews's attorney, Charles Victor McTeer, a young Black protege of the Center for Constitutional Rights, enlisted social psychologist Kenneth Clark of the famous Dahl study cited in Brown versus Board of Education, and civil rights leader and local leader Fannie Lou Hamer to testify on the plaintiff's behalf. When school officials argued that unmarried parents set a poor moral example for impressionable students, the plaintiffs and their allies countered with a robust defense of single mothers' courage, fortitude, and moral character that emphasized their valiant efforts to obtain education and employment against all odds. This redefinition of sexual citizenship also expanded the scope and meaning of reproductive autonomy. In the early 70s, as abortion restrictions fell and women of color exposed and protested involuntary sterilization, plaintiffs and their lawyers emphasized that the right to reproductive choice should include the right to have children, regardless of financial means, marital status, or the presence of a man in the household. Single mothers' efforts to redefine citizenship also reached military service. And this was a kind of transitional moment in the US military. As the civilian welfare state was crumbling and employment discrimination in the private sector persisted, Black single mothers sought access to opportunities in the military, which was in the process really of retooling itself as an all-volunteer force after the Vietnam War. And one of the ways that the military was attempting to attract recruits was by providing generous benefits as well as career opportunities, primarily intended for married service men and their families. So sort of building up what historian Jennifer Middlestadt calls the military welfare state. In Mack versus Rumsfeld, 5 Black women challenged military enlistment policies that excluded single parents unless they were willing to relinquish custody of their children, ostensibly because they couldn't simultaneously meet the demands of military service and family care. They argued that this policy burdened the fundamental right to have a family and discriminated against women, especially women of color, who were on whom this policy had a measurable disparate impact. Notably, they also argued that single mothers who relied upon extended kin networks, especially care by grandmothers, were family pioneers and models for modern white families seeking to balance work and family responsibilities. Pioneering Black social work professor Patricia Morrissey testified on their behalf that single mothers of color were especially well-equipped to juggle military and family responsibilities, given their exemplary reliance on extended family networks for childcare. And the final example that I'll mention is the struggle against discrimination in the housing rental market, documented in a 1974 study by the Department of Housing and Urban Development in collaboration with the National Council of Negro Women. During this period, and many other periods, an affordable housing crisis affected many Americans. But single mothers of color, regardless of income, but particularly low-income single mothers of color, faced an especially hostile market. Assumptions about their ability to pay rent, to maintain their homes, to adequately supervise their children, and to keep men considered undesirable away, resulted in rampant discrimination that landlords often did not bother to hide. Lax enforcement of existing laws against race and sex discrimination in housing, combined with the exclusion of marital status as a category from the Fair Housing Act, meant that victims of discrimination often had no legal recourse. So in all of these challenges to marital supremacy and reproductive injustice in housing, welfare, family law, public employment, military service, single mothers made an array of creative constitutional and legal arguments. And I want to talk about those in more detail now, because they've also often, I think, been lost in our collective memory of this period, in large part because they weren't picked up by courts. So one set of arguments sounded in terms of sexual privacy, freedom of association, and due process. Plaintiffs drew on cases such as Griswold versus Connecticut and later Eisenstadt versus Baird, and notably Roe versus Wade, to argue for a right to have non-marital sex and intimate cohabiting relationships without state interference, intrusion, or penalty. The right, for example, not to lose public assistance benefits, custody of children, employment opportunities, or housing based on marital or family status. The right not to be subjected to punitive measures such as incarceration, fines, child removal, or sterilization abuse. Using equal protection and emerging statutory rights, they argued for a right not to be discriminated against based on race, poverty, and sex. Family status discrimination, they pointed out, often had the purpose and effect of perpetuating both white supremacy and poverty. Poor families also were subjected, they noted, to state intrusions that families of means would never experience. Increasingly, they also used emerging principles of sex equality law to emphasize how illegitimacy penalties subordinated women in particular. Mothers, they said, shouldered primary legal and social responsibility for the care and support of non-marital children. Sexual double standards often shamed and punished women, but not men, for non-marital sex. And the privatization of dependency in the nuclear family, they said, forced women to depend on men, regardless of how abusive or impecunious they might be. And mothers made many constitutional arguments that sounded in terms of reproductive freedom, the right to procreate, family privacy, and parental rights, regardless of marital status, the right to have children or not, and the right to access the means to care for and support them and to make autonomous decisions on their behalf. So as I've already alluded to, these arguments enjoyed fairly limited success. And I want to identify some patterns in where they did succeed and where they came up short. So the first theme is that birth status discrimination claims that attack discrimination against children, against so-called illegitimate children, that vindicated the rights of children perceived as innocent, to be free from punishment for their parents' sins, parents, you'll note, not perceived as innocent, tended to be the ones that prevailed. Whereas by contrast, adults' claims to sexual liberty and freedom from discrimination based on marital status tended to fail. States during this period and the federal government largely retained their prerogative to privilege and promote marriage over non-marriage and to penalize adults who resisted heterosexual marital norms. So for example, in Barbara Jean Cager's case, a Maryland court halted the punitive measures against the mothers, but not because they violated the federal constitution, rather because prosecutors had, quote, used the children as pawns in a plan to punish their mothers for their past promiscuity and to discourage them and other females of like weaknesses and inclinations from future productivity. In King versus Smith, Chief Justice Earl Warren wrote for a unanimous court that Congress had, quote, determined that immorality and illegitimacy should be dealt with through rehabilitative measures rather than measures that punish dependent children. The protection of such children as the paramount goal of AFDC. But Alabama remains, and other states, remained free to, quote, discourage illicit sexual behavior and illegitimacy by other means, subject to constitutional limitations that the decision did not specify. So though an important statutory victory, King versus Smith was hardly a ringing endorsement of Mrs. Smith's claimed constitutional rights to sexual and economic autonomy. This kind of what I'm calling hapless and innocent children reasoning reached an apex in Justice Powell's opinion in a 1972 case called Weber versus Aetna Casualty, which struck down birth status discrimination in workers' compensation. His language here about innocent children punished for their parents' transgressions was quoted again and again in subsequent cases. But none of these decisions so much as mentioned the more expansive constitutional claims made in these cases, nearly all of which were brought by Black single mothers and their children. And with respect to the housing rental market, after decades of advocacy, the Fair Housing Act amendments of 1988 added familial status, which means the presence of children in this context, to the prohibited categories of discrimination. But marital status and sexual orientation remained political non-starters. Okay, so that's one theme. Second theme, when advocates did succeed in defeating formal exclusions and establishing, instead of formal distinctions based on marital status or birth status, establishing functional definitions and standards, it was mostly where that kind of functional turn helped to privatize dependency within the nuclear family. So child support is kind of the classic case of this. Marital status during this period largely stops mattering to whether a parent is going to be financially responsible for their child. And justices who were very skeptical sometimes, of claims about sex and family status-based discrimination in other contexts were very eager to sign on to a series of unanimous decisions in the 1980s that ruled statutes of limitation on paternity establishment unconstitutional. So in other words, where single mothers were making claims to freedom from discrimination based on their marital status, they were succeeding in situations where doing so protected the public risk. Compared to the outcomes for the three groups I talked about earlier, the aspiring Mississippi school teachers, the mothers resisting mandatory paternity disclosure, and the single parents trying to enlist in the Army and the Air Force. Of these three groups, only the teachers succeeded. They were able successfully to frame themselves as responsible citizens trying to support themselves and their children without any help from the state. The indigent mothers, of course, who were compelled to disclose paternity could not make such a showing. And even the single parents seeking to enlist in the military were perceived as demanding benefits to which married servicemen were entitled, but single mothers whose childcare responsibilities would supposedly divert them from their duties and or burden the military with additional costs did not deserve those opportunities in the view of the government and of courts. Okay, and the third theme. Functional standards and definitions, while I think clearly an improvement on rigid exclusion, proved to be a mixed blessing. The public employment context is a case in point. So in cases involving teachers and librarians discriminated against for engaging in non-marital sex, courts began to impose what they called sometimes a nexus requirement. Non-marital pregnancy or sexual orientation or non-marital cohabitation could no longer be the sole sort of per se ground for excluding people from these jobs. But when courts began to require a link between the non-marital sexual conduct on the one hand and job performance on the other hand, decision makers were easily able to smuggle back in these moralistic judgments into their analysis by, for example, characterizing negative community reaction to non-marital sex as a barrier to teachers functioning on the job. Similarly, administrators and courts found the per se exclusion of non-marital families from public housing to be impermissible. But officials often retain case-by-case discretion to make judgments about whether an individual mother's supposed immorality would make them bad tenants. Children could not be removed from their homes any longer merely because their mothers had children outside of marriage. But authorities retain the ability to remove children for neglect, often and increasingly a synonym for poverty rather than abuse. So why did these challenges to marital supremacy and reproductive injustice fall short? Well, one obvious answer is that Black single mothers were making these claims in an increasingly inhospitable political climate, right? Just as sex equality and reproductive justice and anti-marital supremacy arguments were coming into their own, conservative counter movements are gaining steam and political power. This conservative turn limited both directly and indirectly how successful these challenges to marital supremacy could be. But this isn't just a story about conservative backlash. It's also the case that resistance to marital supremacy was not a concerted social or legal movement pursued by an organization or organizations devoted to that cause, right? Unlike the model pioneered by the NAACP Legal Defense Fund of painstaking incremental litigation, or even the more diffuse but still somewhat coordinated efforts to dismantle legal inequality based on sex, this was not such a coordinated movement. Individuals who were associated with other movements often played key roles, but many of the lawyers and advocates in this story saw undermining marital supremacy as less as a sort of primary mission of what they were doing and more perhaps as a collateral consequence or incidental consequence of their advocacy efforts. Many ordinary Americans who pushed these marital boundaries did so because they had something precious to gain or lose, right? Parental rights to a child they loved, a hard-won career as an educator, or the freedom to make decisions about their bodies and families. And perhaps even more significantly, those who resisted or sought to reform the legal regime of marital supremacy really did not agree on the nature of its harms or on how to remedy them. Lawyers and scholars were not foregrounded in my talk today, who were united by shared commitments to causes such as ameliorating poverty or promoting women's and children's welfare, had very different ideas about gender roles, the relationship between poverty and family structure, and the proper place of the state in all of this. For many liberals, as well as conservatives, marital supremacy and the privatization of dependency in the family were positive goods and perceived as central to overcoming white supremacy and poverty, not to perpetuating it. Okay, so in closing, I'm just going to say a few words about the consequences and legacies of marital supremacy's survival into the 21st century. In the 1990s, a spate of legislation raised the stakes of marital status, actively favoring the affluent and married and disfavoring the poor and unmarried at a time when marriage increasingly correlated with race and socioeconomic status. From welfare reform to immigration law, to the FMLA, the Family and Medical Leave Act, to the Defense of Marriage Act, penalties for non-marital sex, relationships, childbearing, and parenthood suffused federal law. And I think it's fair to say that the limited success of the 60s and 70s efforts haunted opponents in this regard, and rendered the federal constitution a mostly ineffectual weapon for challenging these laws. Fast forward to the present day. As you all know, in June of last year, the Supreme Court upended a half-century of precedent in Dobbs versus Jackson Women's Health Organization, extinguishing the constitutional right to abortion and calling into question other liberties protected by privacy and substantive due process, including contraception, same-sex sex and marriage, even interracial unions. In the aftermath of Dobbs, Democrats in Congress introduced legislation designed to codify protections for abortion, for contraception, and for marriage equality. And notably, during this time, progressives also were seeking to extend, have been seeking to extend the child tax credit that was expanded during the pandemic, which had reduced child poverty by as much as 45 to 50% and cut the number of Black children living below the poverty line in half. Of these initiatives, I think it's significant that only one of them succeeded. In December, President Biden signed the Respect for Marriage Act into law. And so amidst the greatest retrenchment of constitutional rights in generations, and faced with a rare opportunity to address economic and racial inequality and shore up basic individual freedoms, only marriage ends up winning protection. So today, as in the past, challenges to reproductive injustice only sometimes, and probably increasingly less often, take the form of challenges to marital supremacy specifically. And while there remains no legal or social movement devoted to challenging marital supremacy, there is a much more visible, robust, and concerted movement for reproductive justice and a more urgent need for such a movement than ever before. So I'll stop there. Thank you, and I look forward to your.
Thank you for that. We have some time for questions, and Professor Mariani will respond to them.
Yes.
Professor Myrie, that was a great talk you also enlightened. I come from India, so we have a different position there. Very interesting to see the historical perspective. My question is, do you support today the childbirth outside the marital marriage? And what is your take on increasing state responsibility or the kind of burden on state if this is not restricted?
Yeah, so I'm primarily a historian, but I do have a view on this, on these topics. And I guess, I think what I often need to clarify is that, I'm happily married and have children as a result of that marriage. And I think my interest in the topic and my quibble with how this has all unfolded has to do really with the supremacy of marriage, with the privileging of marriage. And I think generally the approach in the United States to non-marital childbearing has been one that has been punitive in ways that has aggravated both poverty and white supremacy, despite the fact that I think there are many people who sincerely believe that the causation that I'm sort of attributing to these developments is backwards. So there are many people, and this is part of what my project is about, many people who think that what we need to do is to continue to discourage non-marital childbearing so as to promote marriage and thereby reduce poverty. But I think that the concept of privatizing dependency within the family is a very problematic one, recognizing that, and I think this is becoming increasingly clear to me as I move through this project, that to do so, to challenge the legal primacy of marriage, really requires a very significant, if not transformative, overhaul of our whole political economy. And I'm sure that would be true not just in the United States, but it's particularly true in the US, given how many government and private benefits are channeled through marriage and other family relationships to a greater degree than I think in a lot of societies.
I was curious if you could say a little more about the conservative backlash, because at various points, conservatives were torn, I guess, between a deep investment in marital supremacy and concern about what it would mean for what they saw as reproductive injustice, although I don't agree. Especially with respect to things like people's willingness to have abortions. So is there sort of a conservative turn too that made investment in marriage more important in that agenda? I mean, my guess would be yes, with sort of small government Republicanism, but I'm curious because it seems like there could be more than one conservative response to the claims that you're making.
Yeah, absolutely. So, I mean, one of the challenges of this project for me has been also defining whom to characterize as conservative, because I think there are many people who I'm talking about who are, they're Democrats. They would define themselves as liberals. And certainly the liberal consensus at the beginning of my period is very much in favor of this kind of breadwinner liberalism that promotes marriage and privatizes dependency in the family, even though it's somewhat more receptive to the provision of government benefits. So that I think is one thing that's sort of important to note. There are also moments, and I know you've identified a lot of these moments in your work as well, where there are kind of alignments of interest between people who we might, more conventionally describe as social conservatives on the one hand, and folks who are concerned about the treatment, for example, of non-marital children in particular. And I think part of that is expressed through this kind of language about innocent children not being punished for their parents' sins, which is common, almost across the political spectrum throughout this period. But some of it arises in contexts that I didn't have a chance to talk about today. For example, one thread or controversy on the sort of center left during this period is over the appropriate role of non-marital fathers in the lives of their partners and former partners and children, or the lives of the mothers of their children and their children. And that's an area where you do see sort of significant alliances is too strong a word, but significant convergences between some feminists who think that it's really important for mothers to have control over whether their children's fathers are actively involved in their children's lives and thereby in their own lives. And for example, are anxious to make sure that mothers have the opportunity to place their children for adoption if that's what they decide to do without interference from the fathers of their children. And that dovetails with, sort of conservative, anti-abortion, pro-adoption advocates, and who also are folks who are in favor of promoting adoption, of course, are not just on the right. So it's a complicated story, but I think you're really also right to point out that there are important changes happening to conservatives and the conservative movement over this period that my project doesn't focus enough on, but are definitely important to consider.
Do you see any connections between this story and the movement to liberalize divorce laws during the same period? And were the differences between how divorced women were treated versus women who had never been married?
Yeah, that's a great question. So yes, absolutely. And that is actually part of my book project a little bit as well. But there's an excellent recent book by Suzanne Kahn called Divorce American Style. It really takes you through this same period with respect to divorced women's advocacy for greater equality in benefits with married women in things, everything from Social Security to health insurance, et cetera. And what she argues is that one of the ways that divorced women's advocates during this period succeed in expanding to a small but somewhat significant degree eligibility for things like Social Security benefits is by drawing a contrast and distancing themselves from single mothers who are not divorced but were never married. And drawing on some of the racial and class connotations of that difference was an important part of their strategy, particularly in the 1980s, as the prospects for expanding the welfare state, or maybe it's better to say the ability to resist contractions in the welfare state is diminishing, increasingly. So that's another important sort of historical backdrop to this story. Is I've focused in this talk mostly on the 60s and 70s, but once you get to the 1980s, everyone's playing defense in the story to a degree that wasn't as much the case in